proposed rule to significantly change the public charge rules as they pertain to immigrants.
Thank you. Is there a second?
Emma Dickinson. Aye. Second.
Thank you, Madam Vice Chair. Commissioner Narasaki, will you begin our discussion? I
will.
So I'm sorry. I was just going to recommend that to move.
Yes, actually, that was how I was going to begin. Since this is a filing in opposition to a notice of proposed rulemaking, I don't, and it's a very lengthy piece, I don't think it's helpful to read it. All the commissioners received a draft of it from my special assistant, Jason Legria. I'd like to thank him and the other special assistants who have helped to work on it. This is an issue that I have been working on for, I think, pretty much the 25 years that I have been in Washington. And what the USCIS is proposing to do is to make it even more difficult for immigrants to reunite with their family members. There is a requirement in the law that when looking at people applying for admission, need cash assistance, and that has been how it has largely been defined for a quarter of a century now, almost, and will vastly would expand on a prospective basis what that means. It is done on the totality of circumstances, which are rather raises the concern that opens up the ability for there to be discrimination in its application, and also tries to do something that some people have been trying to do in efforts to change the immigration laws, and that is to introduce by the backdoor requirement of some English fluency before people would be able to enter. We also think that it puts at risk people whose circumstances may change after they come here. They often come here and do dangerous work and may get injured along the way. They often have citizen children who then would not be able to receive assistance and who would be growing up without the necessary resources to make sure that they can eventually become fully effective and contributing adults. So I will stop there and see if there are any questions.
Commissioner Narasaki, this is the chair. I want to thank you for exercising your leadership to move us in this direction to expertise of the commission in submitting public comments for a proposed regulatory rule. I think that it is an important way to use the voice of the commission and the expertise of the members of the commission, and I appreciate your leadership in that respect with this as a device and also on this very important issue. I plan to vote in favor of the draft that you shared.
Yeah, I appreciate that. And I should add the challenges that because this law would fall disproportionately on different national origins, that would be discriminatory.
Any other discussion on this motion? Hearing none, I'll call the question and take a roll call vote. Commissioner Degblay, how do you vote?
Aye.
Commissioner Harriet?
No.
Commissioner Kirsnow?
No.
Commissioner Chladny?
Yes.
Commissioner Narasaki?
Yes.
Commissioner Yockey?
Aye.
Vice Chair Timmons Goodson?
Yes.
And I vote yes. The motion passes. 2 commissioners opposed, no commissioner abstained. All others were in favor. We'll now turn to another amended agenda item, which is a discussion and vote on a statement regarding the Commission's legislative and oversight priorities for the new Congress. circulated earlier this week.
Very good.
To open the floor for discussion, I move for approval of the statement as circulated by my special assistant. Is there a second?
Gladney, I'll say.
I second Commissioner Narsaki.
Thank you. I'll begin with a discussion of a few points, and I will, I think, depart from our tradition of reading it into the record because it is also quite long. It's 5 pages, unless anyone particularly wants to hear the melodious tone of my voice at that length.
Let me think about that. No.
Fair enough. So let me just describe the goals of this draft that I know we have all seen, and that is Congress' mandate to the Commission is to advise the President, Congress, and the public on civil rights policy and the state of civil rights in January 2019. And given the volume of work and the important issues always facing Congress, I think it's prudent to provide a priority list from the Commission to highlight key recommendations resulting from the Commission's focused attention and research over the last few years. The urgent message that we would send to Congress with this statement is that Americans need our members of Congress to prioritize civil rights laws and see if there's any further discussion on the statement. Hearing none.
This is Narsaki.
Go ahead, Commissioner Narsaki.
I want to applaud the chair and her special assistants for their hard work on this letter. I think it is very appropriate with new Congress coming in and with so many new members to educate Congress, as is our mission, about the concerns and recommendations that the Commission has been raising recently, and look forward to in my vote.
Thank you. No further discussion. I'll call the question and take a roll call vote. Commissioner Degbele, how do you vote?
I vote aye. However, I would like to note on the letter that I take no position with respect to the recommendation regarding consent decrees, and I would appreciate it if the letter would so reflect.
Thank you. Commissioner Harriet, how do you vote?
No.
Commissioner Kirsnow?
No.
Commissioner Gladney?
Yes.
Commissioner Narsaki?
Yes.
Commissioner Yaki?
Aye.
Vice Chair Timmons Goodson?
Yes.
And I vote yes. The motion passes. 2 commissioners opposed, no commissioner abstained, and all others were in favor with the note to be added that Commissioner Degbele raised. We now turn to another amended agenda item, which is a discussion and vote on the statement regarding citizenship. To begin discussion, is there a motion?
Yes, this is Commissioner Narsaki. I move that we amend U.S. Commission on Civil Rights warns against citizenship, continued hostility to immigrants.
Thank you. Is there a second?
Second, Commissioner Yaki.
Thank you. To begin discussion, we'll start with Commissioner Narsaki.
Yes, this is fairly brief, and so I will go ahead and read it.
Thank you.
The U.S. Commission on Civil Rights strongly opposes the President's announced intention to attempt to end citizenship for children born in the United States to non-citizens through executive order. The President's proposal continues a troubling pattern of statements expressing hostility and animus toward immigrants or their nations of origin that this Commission has previously noted. This attempt is just the latest manifestation of policies such as the Muslim ban and the proposed expansion of public charge determination to curtail immigration from marginalized communities that threaten the dignity, well-being, and civil rights of immigrants and citizens in our country. Attempts to end citizenship for children born in the United States would clearly violate the plain text of the 14th Amendment, which states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The Supreme Court has been clear on this subject. In 1898, the Supreme Court held in United States versus Wong Kim Ark that a child born in the United States to Chinese nationals who themselves were barred from becoming naturalized U.S. citizens was entitled to citizenship under the 14th Amendment. In 1982, all 9 Supreme Court justices agreed in Plyler versus Doe that the Equal Protection Clause applies to undocumented immigrants physically within the jurisdiction of state no less than it does to documented immigrants and U.S. citizens because they are subject to the jurisdiction of the United States. Scholars across the ideological spectrum have also pointed out that the original intent of the drafters of the 14th Amendment was for the amendment to be broad and sweeping with very limited exceptions. More than 13 countries offer similar birthright citizenship. The president's proposal is a violation of the civil rights and equal protection of native-born children of non-citizens that diminishes the rule of law in our country. We strongly advise the president to reconsider and publicly disavow any further efforts to end such citizenship.
Thank you. Commissioner Narasaki, is there any discussion of this proposed statement? Commissioner Harriet?
I suspect that Commissioner Narasaki is correct about the interpretation of the 14th Amendment here. But that's just, alas, just a suspicion on my part. The text, I think, seems to go with her. I have not read the argument in the other direction yet. And I feel like I can't weigh in on anything other than my gut reaction is the text is with Commissioner Narasaki. And the text matters a whole lot. Even if I'd read Professor Eastbury at this point and formed a firm opinion that Commissioner Narasaki is correct, this particular document is not something that I could support. But the basic notion of what the 14th Amendment requires, again, I think she's probably right, but I can't say that definitively until I've read the argument going the other way.
That's fair. Thank you.
I'll take a probably right from you, Commissioner Harriet.
Yeah, well, maybe at some other point I'll have a final opinion, but right now I just have to abstain.
Thank you. Commissioner Degley?
Madam Chair, I want to pick up on a point made by Commissioner Harriet. There is a sense in which the animating events for this statement are in part about rhetoric. They're about the rhetoric of our nation's leader who has chosen a path of demonizing human beings on a categorical basis who hail from various parts of the globe on the strength of their national origin, their religion, rather than pursuing a path of using the bully pulpit to take exception and note where the policies or leadership vision of foreign leaders is inconsistent with American interests. So rhetoric is important in public policy, but it's important to have leaders who don't engage in categorical demonization of people on the strength of where they were born, what the circumstances of their birth are, or their religion. And so I would like to note that this statement is important because it doesn't stop with rhetoric. Rhetoric can sometimes form the basis for policies, and those policies can have effects when joined with the dangerous rhetoric that is inconsistent with the American idea, with our history, and with our finest traditions.
Commissioner Turcino?
Thanks, Madam Chair. I would largely concur with what Commissioner Harriet just stated, although I would note that I think it's everyone to engage in a bit of humility as to whether or not the 14th Amendment applies to this situation. I do think that, first of all, at the time the 14th Amendment was promulgated, no one contemplated this particular issue. But to the extent there was any discussion about it, two of the principal directors, Turnbull and Jacob Howard, suggested that it wouldn't apply as this statement would have it apply. That is, it would not apply to the children of immigrants born in America. But I would say that it's a close reading. If you look at the text, I would think the clear reading of the text would say most likely individuals born in the United States, regardless of circumstance, are entitled to citizenship. But beyond that, this document isn't correct in terms of its description of Wong Kim Ark or of Plyer. In Wong Kim Ark, the distinguishing feature there is, even though these were Chinese nationals, they were lawfully present in the United States. Second, with respect to Plyer versus Doe, that was a narrow reading. That was a very narrow case. This suggests that somehow Plyer versus Doe says that illegal immigrants born in the United States are then entitled to citizenship, or the children of legal immigrants born in the United States are entitled to citizenship. And if you look at Plyer versus Doe, there are a number of statements by the various justices there that indicate that although individuals present in the United States are subject to the equal protection of the law, that doesn't mean that a category of citizens or all categories of individuals are treated identically. There may be classifications of individuals treated differently for a host of reasons. So for that and other reasons, I would be voting against this.
Would be a substantial difference in treatment to say that you could not be a citizen as a category. So I do just want to point out that there's a strict textualist reading of all persons born or naturalized in the United States does suggest that unless these children are not persons, they are citizens under that amendment. Commissioner Narasaki.
I just wanted to note that we're using Plyer versus Doe for the finding that that children, undocumented children born here are subject to the jurisdiction.
Commissioner Narasaki, I noted.
Madam Chair?
Sorry, go ahead, Commissioner Yaki.
I just wanted to make a brief statement. The cases, the civil rights cases of the late 1800s and early 1900s were brought by members of the Chinese American community at the time, a community that had been the subject of distinct and overtly racist laws designed to prevent them from entering the country, owning property, really having the full rights that every American or every person who is in this country should be allowed. And part of my pride in being half Chinese American is knowing that these were individuals who decided to challenge the interpretation of a law brought down against them by a power structure that was white and male, and let's just be factual about it, and went to a Supreme Court that was also white and male and found these rights to be self-evident in the plain wording. And they pooled their money together. They worked together as a community to fund these legal challenges. This was not something that they took lightly, given their status and the fear of retribution for them. And we have to remember that and remember what it is that they did for every American who is here now, every immigrant family, for everyone who came through Ellis Island or Angel Island. Their children became Americans. And the idea that one set of people or sets of people, whether it's by faith or by the color of their skin, somehow are not eligible to receive the same types of benefits that millions of others who are now second and third generation Americans is ridiculous. And the rhetoric of a president, as Commissioner Dagley said, means something, especially when it means changing the very nature of how we are defined and who we've seen ourselves and who we've become as Americans. And so I strongly support this statement. I would have put perhaps even more inflammatory language that would have made Commissioner Harriet or Commissioner Kirsnow even more on edge. I did not, but I would say that this is Wong Kim Ark, Yikwo, others are things that should be taught in every history book about how this Constitution and its amendments were meant to protect and bestow rights upon every person in this country, and not just for a select few.
Thank you, Commissioner Yaki. Commissioner Narasaki, I noted when you read the statement, I think you added such before citizenship in the last line, and I liked that amendment, and so want to offer it as a friendly amendment to the text if you would be willing to accept it. So that the last sentence of the statement would read, "We strongly advise the president to reconsider and publicly disavow any further efforts to end such citizenship."
Yes, I would accept that amendment. And I'm a little worried about the title because it seems a little bit overbroad in the way we phrased it, that we're somehow the effort to end all citizenship is happening. I was trying to avoid the use of the term birthright citizenship, but I would add it there just for clarity so we don't cause a huge panic.
Okay, so unless there's further discussion with those two amendments, I'll call the question, take a roll call vote. Commissioner Degblay, how do you vote?
Aye. Aye.
Thank you. Commissioner Harriet?
Abstain.
Commissioner Kirsnow?
No.
Commissioner Cladney?
Yes. Yes.
Commissioner Narasaki?
Yes.
Commissioner Yaki?
Aye.
Vice Chair Timmons Goodson?
Yes.
And I vote yes. The motion passes. One commissioner opposed, one commissioner abstained, and all others were in favor. Next, we'll hear from Staff Director Mauro Morales for the monthly Staff Director's Report.
Thank you, Madam Chair. I don't have anything more to add than what is already contained in the report. I always remain available to discuss any questions or concerns a commissioner may have about the report or anything else that the commission is working on. I'd just like to say, since this is the last business meeting of the year, I want to extend good wishes to commissioners, special assistants, and all our staff for a wonderful job they did in 2018. And I want to also wish everybody a wonderful holiday and a safe one as well. So thank you, Madam Chair.
Thank you. If there's nothing further, I will hereby adjourn our meeting at 11:24 a.m. Eastern Time. Thank you.
I would like to wish everybody a Merry Christmas and Happy New Year and any other holiday that is happy and celebratory before the end of the year. Thank you.
Thank you.
Yes, I would also like to add my best wishes since I'm going to miss the holiday party today, but and also really want to thank the staff for, I think, an extraordinary year of production, and very much appreciate the hard work.
Thank you.
Thank you. Ladies and gentlemen, this concludes today's teleconference. You may now disconnect.